declared.
He went through that.
He did.
I sorry.
Yes, sir.
And that said that you've got to declare under penalty of perjury that you're going to be occupying or selling. Is that
Right.
correct? And the notice just said we plan to occupy and sell. It didn't have the attendant sworn language at the bottom of the form. Is that correct?
That is correct. So
Okay.
the clarification was that originally the notice did not require the landlords to have an affidavit that they intended to occupy or sell the unit. And that is correct. In fact, at Dzaman, I don't believe the court knew whether or not the tenant had been evicted. So they considered mootness, but then they also considered that this was of great public importance. And so, yeah, the tenant moved to rescind the writ, before the sheriff had actually carried out the eviction. And that's what went up on appeal. So, okay.
Interesting timing in that case.
Oh, hey, there we go. Is that the next one? Yes. Okay. So, do you want to say anything about the side and then I can damages?
Yeah, not in particular. You can go ahead
Okay.
and lead off.
Well, as I said earlier, the city is collecting information but not enforcing the Landlord Fairness Code. I do have a parentheses because there is a section of the Landlord Fairness Code, and I actually brought this up to the city at one of their hearings. Didn't get very far from the tenant perspective about the non-exclusive remedies clause, because there is a clause in the let's see. I'm trying to get the exact site. Okay. It's in part 3 of the Landlord Fairness Code that talks about remedies are in addition to any other existing legal remedies and are not intended to be exclusive. So I read that as potentially the city could enforce the Landlord Fairness Code if they want to. They do not. And I think there were some political reasons why it didn't have a city enforcement mechanism. So this is a private right of action. Again, as I stated, the tenant needs to either do this defensively or offensively. I think it's mostly coming defensively right now that the tenants are bringing counterclaims for violations of the Landlord Fairness Code. They could also do it offensively though, and that I think comes into play specifically with the relocation assistance that can be demanded under the Landlord Fairness Code. So if the landlord is refusing to do that, the tenant says, hey, they should have offered that and they didn't, they can bring suit. And so that would be the offensively. Is there anything you wanted to say? No? Okay. All right, so these are some example violations under the Landlord Fairness Code. Interestingly enough, there's another distinction between what the city's enforcing versus what the Landlord Fairness Code, and that has to do with the late fee. Under the Landlord Fairness Code, it's capped at either $10 per month or more than 1.5% of the rent. Under the old ordinance, TMC 1.95, it's $75 is the late fee. So the city would come in and enforce a late fee of more than $75. They would not do anything about the late fee of more than $10 or more than 1.5%. But the tenant could bring the suit or raise that as a counterclaim. The pet deposit cannot be more than 25% of the rent. The landlord cannot charge a non-refundable fee. I believe that was also in 1.95.
Oh, sorry, Barry, I'm gonna, if I can interject in each one of these. So just with regard to the pet deposit, I just want to talk about that. I realize we're talking about in the context of a sample violation, but in looking at that as an allowable fee, I get asked this a lot as far as 25% of rent. What does that mean? What does rent mean? And you know, if you want to be conservative, it'd be 25% of base rent, but the code does define rent the same as a state statute, that it's the monthly base rent together with any utilities and any periodic monthly charges. And so that would mean that if your tenant is also paying for, say, parking or storage or tenant insurance, all those are considered rent. So the landlord would have an argument that that 25% isn't just 25% of the base rent, but 25% of the base rent plus what the utility charge would be, plus whatever these monthly periodic charges are that all meet the definition of rent.
The actual definition is any recurring or periodic payments for the use and occupancy of the dwelling unit, which may include utilities. Rent does not include any non-recurring charges such as late fees, notice fees, attorney fees, court costs, damages, or other fees. So I think there is an argument that it's broader than just the base if it's a payment that's required for the use and occupancy of the dwelling unit.
That's correct. Yeah. So,
again, I have a question. You suggested that this is not a remedy the tenant can recover funds on, penalties on. Is that what you're saying? That Tacoma is the only entity that could recover penalties, or are you saying, I mean, does it support the tenant having a
yes,
remedy?
it does. The tenant has a private right of cause of action.
Is that included in this section?
It is, yeah.
It is, yeah. That's under the Landlord Fairness Code. What I meant to say earlier, if I wasn't clear, was that the city of Tacoma is not enforcing TMC 1.100 where it differs. For example, the late fees. Again, the city of Tacoma wouldn't assess any penalties or go after a landlord for, a $15 late fee, but the tenant could bring a private right of action for the $500 and whatever was collected in excess of.
Is that contained in the ordinance?
Yeah, it's contained in of the Landlord Fairness Code. Yeah, it's private right of action.
And I'm sorry, just one last comment where we're talking about the pet deposits. I'm trying to know these as you go through. So with regard to the pet deposit, what isn't used is refundable to the tenant. So if you charge a pet deposit, and let's say it's $200, and when you go to do your disposition after the tenancy, and you only have $100 worth of carpet cleaning, you don't get to retain the balance of that deposit. It has to be returned to the tenant. Okay.
So if I understand this right, the landlord charges more than $10 per month in their office, because most of these are all going to apply to mom and pops. I mean, they're the people who don't read the laws and understand them. If you have a $20 late fee per month, then the tenant will get $500.
If they bring suit, because that would be any violation of the Landlord Fairness Code. And so that's under Section 8, which is the penalties and procedures. A landlord who violates this chapter shall also be liable for penalties of not less than $500 per violation, and up to 5 times the monthly rent of the dwelling unit at issue per violation. So if the tenant is able to prove that by preponderance of evidence, then they can bring
They just have to show their
suit.
lease that says that the landlord charges $20 a month, give me $500.
Well, if the landlord were actually charging more than $10 or after December 8th, right? Because that would be the
Sure. I mean, the people that don't know this come mom and pops, right? So I get calls, all my commercial landlords get it. They understand all this. It's the person, the old lady that owns 2 homes and her husband gave them to her. She calls, and they're the ones that are the ones going to be at risk on this. So if they do charge $20 a month, it's better for us to give them the $500 immediately.
Well, so the question was for the mom and pop landlords, especially that may not be aware of this, the Landlord Fairness Code and the late fee in particular, whether they should just simply offer, I guess, a payment of $500. I would say that potentially. I mean, the question I think for the attorney and for the landlord is, well, what does that tenant want? Maybe the tenant wants to be released from the lease, right? Maybe the tenant wants something else.
Because my commercial landlords will not violate these. They get it.
Yeah.
These are all going to be the people who want 1 or 2 homes, right? They call and say the tenant says, I took $500 for a pet deposit, the rent's $1,000, they want me to give them $500, so they're going to sue me. I've got to tell them, give them the $500.
Well, so the question would be, should the lawyer advise the client to just give them the $500?
No-brainer, right?
Well, it's because otherwise they'd have to pay their attorney, right, as well. So yeah, it probably does make sense. But
Okay.
Adam, is there
But,
anything else?
yeah,
you
I mean,
wanna add?
in a situation like that, it probably wouldn't hurt to have a conversation. I mean, unless your tenant is coming out guns a blazing, you
Yeah.
know, it'd probably be a good idea to approach them. I mean, if the tenant is coming to the landlord and saying, I want my $500, right?
They read this law,
Okay,
they see
so,
the violation,
yeah.
and the tenants are wiser now than I've ever known them to be.
sure.
Because I get a lot of answers in saying, citing right to here and
Yeah.
saying, hey, it's just a no-brainer. I got to tell her to give it.
So-
Because none of my
Sounds
big
like
guys-
sound legal advice, unless they want you to go and argue it and try to find a means around.
I
Yeah,
just need to know what to tell them.
yeah,
And if hopefully I can tell all the people that regularly I do evictions what to fix.
right.
It's the people that only have one or two
No.
units that.
Just don't tell them that Beverly and Adam says you got to write the check.
Right, okay. Okay, but I get it. It's a very difficult for the small landlord because they won't know any of this.
Right.
It also brings up an excellent point in terms of this statute, the language in the statute. Any analysis of whether a contract that violates it, but not collection of. In other words, we have an older contract. Landlord has never modified it and it exceeds these limits, but he never
No.
collected a dime.
Yeah, I think Beverly raises a good point that you have to look at when the contract was executed compared to the enactment of the code. So
Right.
if you have, you know, clients that are still using their leases from 1950
Yeah.
and they signed a lease on January 1 with the new tenant, I think they're going to have a problem.
Right.
Or the landlord can be advised to sign a new rental agreement that
Well,
complies.
my deal is like
Yeah.
commercial landlords, it's easy,
Oh, sure.
right? We just
Yeah.
give them the rules and tell them to comply. It's the people that have one or two homes that don't attend this kind of seminar and don't
Mhm.
think, and they've been doing what their husband's been doing for 30 years.
Well, I was thinking about a landlord who just doesn't charge it, doesn't add to that, and doesn't even try to collect it from the lawsuit.
Right. I think the code is fairly clear that it has to do with the language in the lease and not the,
Oh,
yeah,
really?
and
Just the language in the lease would be
Yeah.
a violation.
I believe that's
Violation
correct.
on all mine.
Yeah.
My late fee
Oh,
said-
I believe it says that the lease
Time
can't,
to update
Yeah.
them.
yeah.
I mean, the tenant's still gonna have to find their way into court though, and still have to, you know, draft
It's
the
an
rate.
affirmative,
Yeah.
strict
Mhm.
problem for a landlord.
I think the way it's worded, yes.
I don't know if I kind of a question and answer straight, but it's early to tell right now, but I wondered if you thought this was increasing or decreasing the amount of rentals that are available in Tacoma. One of the arguments against the referendum was that it was going to cause the mom and pop renters to say, I'll put on my market. I wondered if you had noticed any sort of trend of people getting out of the rental business.
So I will say that there's some interest in studying that potentially at the state or the. So the question was whether or not this is having an impact on the availability of rental housing stock in terms of like smaller landlords selling their properties. I definitely think that argument has been made in terms of the political fight, in terms of the question of whether we're seeing that data. I would say there's interest in studying, and this is at the state legislature. There's some interest in studying the effect of more robust tenant protections on housing availability and on homelessness, but I don't think that has produced any results. But anecdotally, I'm
Anecdotally,
sure.
yeah, I've had lots of clients that certain clients, right, that own maybe 2 or 3 single family residences as rental properties, kind of their retirement. They have all gotten out. They've all, so I'm not talking about Tacoma in particular, but kind of across the board. It's
I
just,
don't understand why this would even apply to
It's-
people who make less than $30,000 a year in rental income.
Yeah.
That doesn't make sense
But-
because you know your mortgage alone is going to be for enough. That's why they didn't do that. But my big clients love it because they're going to be wiping out the little guys.
Yeah.
So they want control, but the little guys are crying and
Yeah.
saying, you know, this is expensive and we can't do it.
yeah, there's certainly a certain level of landlord real estate investors that I'm aware of that have gotten out just because there's just too much damage.
Some are dying to get that, you know, now we can get these properties cheaper.
And not to mention that all the costs incurred by this stuff gets passed down. No
Yeah.
investor is eating costs.
That's
And so the state legislature extremes about affordability of housing and availability of housing. There's
Yeah.
ramifications.
Yeah, and so the comment is being made
And
with,
the rhetoric that they
with-
gave during the conceptualization of this idea,
yeah.
right? Pros and cons of it, right?
And so there's comments within the room are being made regarding the redistribution of the of basically the debt load, I guess, that's occurring from I get the accrual of rent that isn't getting paid by some of these tenants is in fact getting passed on to the tenant market as a whole. I guess would be a good way to say that, right? Yeah. And I think that's a fair assessment, right? I mean, your commercial landlords are out there are, you know, they're watching the bottom line, and they're certainly not going to be losing money. So if they're losing money in one aspect of their portfolio, it will be redistributed, yeah, amongst the others. Yeah.
So there's some other potential violations here. Actually, Amy, can you go back that we haven't touched on? I think one of the potential big ones is the 2 notices that are required before raising rent. That's covered under, let me get this section here.
I got 1.100.050.
Yeah, and that is also tracks the same kind of service requirements as for an eviction. And let's see, and then the relocation assistance that's offered, that depends on the level of the rent. So the question was raised about the overall kind of impact of the relocation assistance as well. It has to do with that. I think what we're seeing is a lot of, 4.9% rental increases, which wouldn't trigger the relocation threshold. And those are, so I think that's more or less what's being done. So it's having the effect of kind of slowing down rental increases, so as not to trigger that. But I think the argument as well is, well, if the amenities and things like that are worth the big rental increase, maybe the tenant will pay it. Or there's also the question of, well, was it underpriced to begin with? So are we ready? Do you want to?
I just want to make one quick comment regarding rental increases and the 2 notices. So if you need the notices, you can do a search for City of Tacoma Landlord Resources, City of Tacoma Landlord Resources, and it has the notices there, but you have to be careful because the first notice is the 210-day notice of rent increase, and it says LFCA or LFCI, which is Landlord Fairness, after it. But above that is a notice that says 120-day notice of rent increase. That is not the second notice, even though the second notice is supposed to be given at 120 days. So ignore that. That one says RHC, Rental Housing Code. You don't want that one. You want the one underneath that says reminder, notice of rent increase. So let me just restate that. So you'll go to City of Tacoma Landlord Resources. You'll see a column that says required notices and forms for renewals. And you're going to use the 2 notices that have LFCI next to them. Okay, don't get confused because the top notice says it's a 120-day notice, and that doesn't take into account LFCI. That was an older notice.
Those forms are available down in the law library. Is that correct?
Amy, are those available at the law library? Okay.
But they are available on the City of Tacoma website under Landlord Resources.
Yeah, under Landlord Resources. And again, please make sure you use those notices that are followed by the letters LFCI. Otherwise, you'll have an invalid notice.
Oh, and we need to wrap this up. Yep. How many, like a few more minutes, or are we pretty much done? We're done. Okay, we're 6 minutes over. So I think, Amy, if you could just go through the next. Yeah, there's a slide about damages. That's under 080. So I think you should definitely read that. And it's not less than $500. The damages for the relocation assistance has to do with the relocation assistance required as well. And with that, I suggest you read the Landlord Fairness Code carefully. Adam, are there any last thoughts you want to offer?
No, just be careful out there. Yeah, make sure you read the code very closely if you own rental property in Tacoma.
Yeah. All right. Thank
Yeah.
you.
One
Thank
final
you.
We'll stay for questions, or I will anyway,
Yeah.
for a few minutes.
Yeah.
Can I ask you one question? It's not on this one.
Sure.
I think so. So Amy, are you closing the recording?
No.
Oh, okay. Well, you can also email me or call me. My information's on the WSBA, Beverly Allen. and Adam Birnbaum.
Likewise here. Yep.
All right. Huh? Oh, WSBA.
Yeah,
Yeah,
WSBA.org.
I look up all the attorneys that way.
I did the same.
So make sure your information's correct.
Thank you all for coming. I
Yep.
really appreciate it. We will have this recording available on the Law Library's website.
Thanks.
Yes, sir.
On some of my orders for writs, right?
Yeah,
I say writ will be issued forthwith, not to be enforced before April 2nd.
yeah. I think if Commissioner Farmer sees that, she's not going to be happy with that. You know, she's been cranking down on that language. Yeah. It's not the end of the world.
Take the word out.
I'm just letting you know.
Same thing, but I think
Yeah.
I like to have them issued now, not enforceable till then.
Yeah.
right? Because then
Because, I mean,
takes
basically,
care
if you don't have
of
the forthwith language, you just have to wait 5 days.
But
So,
then that's the day that it gets writ. It doesn't get issued till April 2nd. and then
Well,
they'll
it's
have-
Well, no,
issued
it's-
and
it's-
stayed.
it's from- it's-
simultaneously issued and stayed. right?
well, no, they're doing a little bit differently.
Really?
Yeah.
They
So
changed that.
Adams used to do it that